Charlie Davis. And this is 25 DCCR 1451 and 1452. What is the announcement?
Judge, we'd like to ask for maybe 3 or 4 more weeks. We're still reviewing discovery. In fact, I'm having a little bit of a discovery issue, but I'm going to be figuring that out whenever I leave today.
Okay. And I know we were going to get some confirmation of non-narcotic medication. Where are we on that?
She did phase down. She went to a new doctor and they reduced the prescription. So she has phased down, and I do have proof of that. I can send it to Mr. Coleman, so he has it as well.
I need you to, if you'll email that to me as well.
Okay.
I need that. I want that today.
Okay.
So get that to me and Mr. Coleman so that we know what's going on, what it was, what it is now, prescriptions, whatever you've got. And then we'll just do a normal reset to give you some time to get caught up on discovery and see if we can get an announcement. Is there any issues, Mr. Coleman?
No, Judge.
All right, Ms. Davis, make sure you stay in touch with Ms. DeLage.
Classic courtroom moment. The judge is basically saying, I'll give you time, but don't make me regret it. Resets like this are lifelines in criminal cases, especially when discovery gets messy. What do you think? Should defendants get more leeway or tighter deadlines?
Everything you're supposed to be on bond, and then we'll see you back at the next court date. All right,
Thanks,
free to go.
Robert.
Thank you. See Mr. Frank? No. Mr. Galmore? Sure. Mr. Gilthorpe?
Your Honor, he went to drug court. He said you're
Okay, thank you. Mr. Price, you've got Dale Johnson.
Judge, Mr. Hopper ran back for just a second.
Okay, I'll hold that for, let me just hold that till Mr. Hoffpower comes back out. I'll just give me a second, I'll recall it. Mr. Lewis, you've got Charles Darling. Good morning.
Good morning, Judge.
Good morning. Are you Charles Darling? And this is 24 DCCR 1384. Mr. Darling's case is set for trial to begin with jury selection next Monday. And what is the announcement?
Judge, we're ready.
States for Your Honor, I would like the record to reflect I have sent letters and subpoenas to all known addresses for the complainants.
Okay. And do you anticipate there being an issue potentially?
Possibly, that's why I wanted to let the court know in advance.
Okay. So then what I'll do, I'll number the case at the probably close to the top so that it gets taken care of one way or the other. If she doesn't show, we're not going to just reset it for that. Since you've sent that out, we'll get it figured out Monday. If she does, then obviously, depending on that order, the case could go to trial.
Okay.
Okay? Thanks. Yeah, no, that makes sense. Thank you. Appreciate it. Mr. Lewis, you've got
Big moment right there. The judge signaling no more automatic resets if a key witness doesn't show. That's the court drawing a line in the sand. This kind of warning puts serious pressure on both sides to be ready Monday. Have you ever seen a case hinge on attendance alone?
I'm in James. Let's see, Mr. Smith, Diamond James. Good morning, ma'am. You're Diamond James. And Ms. James is charged with hindering apprehension or prosecution of a known felon. And what is the announcement?
Judge, I've been talking with Mr. Smith about a possible resolution for
this matter. If we could get one more setting, I think we'll have it disposed of.
All right, it looks like you were just appointed at that last court date. Okay, any issues, Mr. Smith? All right, so Ms. James, I'm going to reset your case one more time. Make sure you stay in touch with Mr. Lewis, so he'll tell you when to be back, and you guys can visit about the case before you come back, okay? All right, you're free to go. Yes, sir, and you've got Michael Thomas, Mr. Lewis.
The bondsman said Daryl Spencer's in federal custody.
Oh, okay, give me just a second.
That's okay.
Remind me after this one, and I'll, because I need to do at large, I guess, instead of a bond forfeiture. How are you? Good morning, sir. You're Michael Anthony Thomas Jr.?
Yes, ma'am.
And this is 23 DCCR 0530. Mr. Thomas's case is set for trial to begin with jury selection next Monday. What is the announcement?
Judge, I would be able to announce I'm ready, but there is one issue. Evidently, there was a TRO hearing that was done recently in regards to these allegations. I'm not representing him on the family law case down the hall, but he did bring me some documentation in regards to that, but I understand it was on the record, and I would like a chance to get the transcript, especially to give him the testimony about the complainant.
Okay. I
I'm
would
okay
think
with
you
that.
would want that as well, probably. So why don't I do this? Why don't I reset it to just a review docket? You guys can both get that
Okay.
transcript, and then if it changes something, then we can revisit. I know this was a plea that was rejected. If
right.
there's something that changes and we go back to something, then you guys can let me know. Otherwise, we'll put it back on the trial docket after that if it's not worked out.
All right.
Stay in touch with Mr. Lewis, and then he'll let you know when you need to be back, okay? And if you'll just make a note that they're getting a transcript of a family case on that one, please, ma'am. So on Daryl Spencer, Ms. Malfino, nope, never mind.
I need her to give me proof, because I looked it up and it says he's not in custody anymore.
Okay.
But I don't know.
The bondsman said that Mr. Spencer may be in federal custody. And so if he is, then I will go ahead and make it, I'll change that bond forfeit.
And there it is. They'll wrap up with a possible shift in bond status, depending on federal custody. When state and federal systems overlap, things get complicated fast. This kind of uncertainty keeps the court on edge because one wrong assumption can derail the entire case. Should bonds automatically adjust when custody changes, or should judges wait for absolute confirmation like this?
To an at-large without proper bond, leave the bonds at 100,000 on each either way, but I would make it at-large, but we're going to get that confirmed before I make that change.
Okay, and I'll check.
Okay, thank you. Mr. Macon, I'm ready on Bethany Loza Diaz, plea. Good morning. Are you Bethany Loza Diaz? Speak up, please.
Yes.
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Ms. Loza Diaz, in cause number 25, DCCR 0928, you're charged with the state jail felony offense of driving while intoxicated with a child passenger from December 4th of 2024. And how do you plead to that charge?
Guilty?
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Macon? Do you fully understand them?
Yeah.
Is there something you don't understand?
No.
Do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind later. Do you understand? And so it looks like the agreement that you reached is for 2 years in the state jail prison, but instead of serving 2 years in the prison, you would be, that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. Is that your understanding of your agreement? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenors number 1.
No objections, Your Honor.
It's admitted. Is there any evidence that Ms. Loza Diaz is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing.